Okay. Um, Hello, everyone. We're going to have a look in this lecture at economic torts. So these tend to be torts that relate to the injury of a business or business's goodwill or reputation. So just going through the list there briefly, passing off it would be a tort going back to the common law times before trademarks legislation and can be still used today in addition to trademarks legislation or in the absence of trademarks protection, passing off essentially relating to a damage to the goodwill of a business where somebody passes off or leads another to believe that they have some connection or their goods have some connection with those of the other business, that other business normally being of a higher standard or quality, thus explaining the injury to the plaintiff's business. You have inducing a breach of contract, similar thing to that, or at least we look at under that broad heading, would be interference with contractual relations. You have fraud or deceit, which is somewhat similar to misrepresentation that you may have come across in contract law in terms of fraudulent misrepresentation. You have injurious falsehood, and another similar one I'll mention called malicious falsehood. And you have the tort of conspiracy. Conspiracy being where two or more people act together with the intention of injuring another's business in a sort of layman's terms. I'll try and keep it as simple as I can for you with these torts. So passing off then is a tort committed by a person who, in a manner calculated to deceive. So you can see there seems to be an element of intention there. They pass off his goods or business as those of another. So his or her goods, if you like, or business as those of another. And as I mentioned, the plaintiff's business is normally injured, and often that injury is a result that the deceiver's goods are of lesser quality. There is, or I suppose, a certain piggybacking, if you like, in the sense of losing sales is another element to it, because somebody is maybe using a very similar brand name or what the court sometimes describe as a get-up of goods. So the goods appear very similar, although they may not be similar, as I say, in quality. So it's a common law action, so it's not to do with legislation, not directly covered by trademarks legislation, and you could bring an action for passing off if you didn't have any trademark. Is a right to protect the goodwill in your business. It has, in some cases, been extended to personality rights, as in your profile is worth money. So there was a case involving Eddie Irvine, the Formula One driver, against an ad that was run by a radio station. The key elements of passing off then, you have to actually have goodwill in the product or business. The other party must have misrepresented, so that I suppose that's your deception element, and there must be some damage or injury caused. They're the three elements. I suppose with the fraud, that's where the intention of fraud tends to be some sort of statement that is made knowingly or not really, recklessly careless, if you like, as to whether the statement's true or not. So that ties in with the calculated aspect. There's lots and lots of examples in the case law relating to passing off cases or actions involving passing off. There's a Jameson whiskey case where there was a John Jameson whiskey and a James Jameson whiskey. You have Griffin which was a Rosslare Hotel and a Rosslare Strand Hotel. So again, 2 hotels in Rosslare, maybe one being already in existence, and then another one comes along. And if it's of a lesser quality, would that have a negative injurious effect on the former? Buy and sell against Auto Trader, so the magazines. So again, buy and sell would have cars in it, and Auto Trader would have ads for the sale of cars in it. So would there be confusion between those two? Not really, as one has lots of stuff in it, not just cars, and the other one is specific to automobiles, if you like. Guinness against Kilkenny, where Guinness had a Kilkenny beer and then some local had a Kilkenny beer. So Guinness tried to prove, and I think successfully proved, that they had established goodwill in the name Kilkenny as regards beer. So that would be very similar to Waterford being established as a name in regards to Crystal and those Crystal related products that Waterford Crystal would have made. There's a CNA Modes case involving a clothing retailer. So one, I think, in Northern Ireland and one in the South. And as to whether there would be confusion between a retailer, with CNA and another one called CNA Modes. There's a Polycell case where they had a product called Polycell and somebody else had a product called Clingcell that did much the same thing. Very simple example here, United Biscuits case, where it's related obviously to biscuits, and there's cottage creams, and somebody brought out a very similar biscuit called college creams. Player and Will's case, John Player cigarettes, the ones in the blue packet were referred to by a lot of people as blues. So they just go in and say, can I have a packet of blues? And question whether somebody else bringing out cigarettes in a similar box with blue on them would be injurious to Player. In the Mitchelstown case, there's a butter called Dairy Gold, and a competitor brought out a very similar one called Easy Gold. And in the Easy Gold tub, very similar color, flour on the lid, and so on. So very similar products. So again, passing off. So final one, I suppose, in a sense, maybe it's a big one because it's still an easily identifiable one for most of us anyway, I think, is Adidas against O'Neill's. Adidas wanted to bring a case, or did bring a case, against O'Neill's because O'Neill's have 3 stripes on their clothing, and Adidas are known to have the 3 stripes on their footwear and so on, and they said this would cause confusion and so on, but the courts found it in favor of O'Neill's, or if you like, against Adidas, and they didn't win the case. Of course, Adidas coming from the name Adi Dassler, who was the German guy who formed Adidas. Interesting aside for you, his brother was the guy who formed Puma. So Adidas and Puma, who were competitors in the footwear side of things traditionally, were actually both owned by two German brothers. So there you go. The next tort then, inducing a breach of contract. So that's where somebody basically gets somebody else to break a contract that they're in, that they might have been happy to stay in had they had there been no fear. So I suppose, you would see something similar mentioned sometimes in relation to the big soccer clubs these days, where agents are trying to get players to break their contract to go and play for another club, and they're in cahoots with the other club and so on. There is an employment law sort of similar version of the idea of getting someone to leave their employment with someone to go and work for someone else. Um, there was an old common law claim or writ for that. It was in Latin, which was per quod servitium amisit, which means by reason of the losing of the services. So going back to the old employment law concept of master and servant, rather than employer and employee, and the idea that if you lost the services of your servant, that you could bring a claim against the person who caused that breach. There's a case on inducing breach of contract. I'm sure there are more than one, but there's one well-known one, Lumley against Guy, where an opera singer was convinced to go and sing in a different opera than the one she was already contracted to sing in. As I say, interference with contractual relations might be considered to be along the same lines. It's also known as tortious interference. And this one really is where two parties have a contract and another party goes and interferes with that. So you're not necessarily inducing someone to break that contract to come and work for you or so on. It may be for some other reason. So I'll actually look at these cases in reverse. So the one that is well known because of the public figures that were involved was Douglas against Hello, and that was Michael Douglas was marrying Catherine Zeta-Jones. So there was two people in the acting industry. I think Catherine Zeta-Jones was in the Zorro movies, and I think Douglas was in a lot of well-known movies as well. So well known that I can't think of any now off the top of my head. But not particularly relevant to law, just pointing out that they were famous. So there was a magazine, I think it was maybe OK magazine or Hello magazine. There was two magazines. They had a contract with one of them, and that they would get the rights to the photos from the big wedding, and another magazine, they got someone to infiltrate the wedding and take photos, and they ran the story first, and therefore the competitor magazine didn't really want to pay loads of money to the Douglases anymore, so they were out of pocket. I guess weddings are expensive. They weren't too happy with this, so they brought a case against Hello for interfering with the contract, which I think was with a magazine called OK Magazine. These are the kind of things I come across if you're in the doctor's surgery or something waiting for your appointments. I don't read them in the evenings at home anyway, but I'm pretty sure there was Hello Magazine and OK Magazine. HB against Mars involved ice cream freezers. It was a tying in arrangement. I might have mentioned the idea of the tying in arrangements if you did any of the contract law lectures with me. So basically HB would give a free ice cream freezer to a shop. And back then shops were a lot smaller than the mega retailers you might come across today. So space would have been tight, and you might have one ice cream freezer and you wouldn't have space for more. So the shopkeeper got the free freezer, but there was a little condition. You could only have HB ice cream in it. Then Mars, as in the Mars bar fame, came along and they decided to do their Mars ice creams. And seemingly, or allegedly, they started telling the retailers that HB were okay with them putting Mars ice creams in the HB freezers. And of course, HB weren't. So that led to the court case. And then, you have a Cooper case again, where a trade union were seen to interfere with an employment contract. It's often the case about in some prior times that in certain course of employment, for example, the likes of construction, for example, where you would have had a lot of workers in the union, they wouldn't have been too keen on non-union workers coming in, say on a building site or something. So they may have made that known. So Cooper is a case involving a trade union interfering with an employment contract. The tort of deceit then, or fraud. So this is where a person deliberately deceives another person into doing something that causes them loss. The Freeman case, the defendant told the third party that someone was creditworthy. Sorry, he told the claimant that a third party was creditworthy, and in fact that third party was broke. So the claimant loaned money to a third party, and of course they couldn't pay it back. And basically, they wouldn't have done this but for the creditworthy reference, and that's why they brought the case against Freeman. So deceit can be difficult to prove. Fraud is known as being hard to prove anyway, because there's this intention, this deliberate element to it that's hard to show. So again, you may have come across this if you've done some contract law under misrepresentation and the concept of fraudulent misrepresentation. And many cases involving fraudulent misrepresentation are not successful and end up being reduced, if you like, to maybe a negligent misrepresentation, which would be a lack of duty of care. So the deliberate element wouldn't be necessary. There is a case if you've done the contract law as part of your module. There's a case, Forshaw against Walsh, involving the Lamborghinis that you might remember, where there was successful claim for both fraudulent and negligent misrepresentation. Injurious falsehood then and malicious falsehood. So injurious falsehood is making a false statement to injure a person in the course of their business. So if you think of slander, in the defamation context of slander, saying something about another person that's untrue and causes them an injury and consequently loss to their reputation. This is quite similar, but it may be designed to injure their business. So I guess, if I walked out of a restaurant and there was people around and I said, I wouldn't eat in there, and maybe added in a few maybe worse things to put them off, that might be the kind of thing that would be injurious or deliberate. And where it's a deliberate false statement to injure somebody, that tends to be referred to as a malicious falsehood. So the difference is, with a deceit, you're saying something to a particular person which will cause loss to that person, whereas with the falsehood, you're saying something not to someone but about a person or business which is going to injure that business. Malicious falsehood is covered under the defamation legislation. It's in Section 42 of the Defamation Act of 2009, and there's a link on the slide there. So when you're looking at the PowerPoint slides yourselves, you can click on that and follow the link to see what Section 42 says exactly. And if for some reason you want to look in the meantime, you simply go to www.irishstatutebook.ie and go to Defamation Act and Section 42. Conspiracy then, I mentioned this at the start, it's where two or more people are acting together or in concert, if you like, with the intention of injuring another's trade or business without lawful justification. It results in a damage. So there are kind of two types. There's unlawful and lawful. So it's either carrying out an unlawful act that causes damage or carrying out a lawful act by unlawful means. It is key that there's two or more persons, so it can't be an individual. And it was used, I suppose, many years ago against trade unions. So trade unions would want to have strikes and so on. And then the question would be that what they were doing was actually conspiracy. So a lot of lawful trade union activities then are going to be exempt simply because they won't be unlawful. But there could be issues with some trade union activities where they're carrying out a lawful act but by unlawful means. And there is a trade union case, a fairly recent one, the Holbrook case, involving a trade union and the rail companies. And if you have a look on bailey.org, Bailey should be on your Moodle page when we looked at the source of the law, and you find the Holbrook case. There's a good description of conspiracy there by O'Neill, Judge O'Neill, and a distinction between the two. Or a very recent case is the Breccia case of 2020, which you could also find on Bailey if you want to follow up a bit more on conspiracy if you find it of interest. And I think one of the issues with the Holbrook case is that the union needed to be registered in some way, according to some statute provision, and the particular union that were involved hadn't been, and therefore they ran into problems in terms of the tort conspiracy. So they're the economic torts. There's as I say, a couple of different ones covered there, and passing off obviously is a considerable one, and then just to be aware of the other ones and how they work and what they are.